Kathleen Kuznicki. I am the chair of the Legislative and Economic Development Committee for the Pittsburgh North Regional Chamber. And when I'm not doing my chamber duties, I am a patent attorney for the Lynch Law Group with offices in Cranberry Township and in South Point. Today, I have the honor and privilege of interviewing my boss, Dan Lynch, about the Corporate Transparency Act, which just came into effect January of this year. Under this Corporate Transparency Act, most chamber members in our footprint are going to be required to report beneficial owner information to the Financial Crimes Enforcement Network under the U.S. Treasury. Dan, thanks for being here today, and thank you for educating our members.
Thanks for having me. I'm glad to do it.
Okay, so let's just start out with some basic questions. So who is required? What is the definition of a reporting company?
A reporting company is just about any legal entity, a corporation, an LLC, a partnership, a limited partnership.
And are there any exemptions under this act?
Yes, there are 17 exemptions, I think. Companies that are exempt are typically banks, financial institutions, any institutions that is already required by legislation to report certain information to regulatory bodies, insurance companies, what affects small business is that if you have more than 21 employees and more than $5 million in business, you're exempt. So what does that mean? That means that if you have under 21 employees and less than $5 million in gross revenue, then you're not exempt and you have to report.
Okay. And who is a beneficial owner of a reporting company?
A beneficial owner is defined by the statute as any person that has substantial control over that enterprise. Substantial control is very loosely defined, and I think that we would say generally it means officers, directors, people that have control over legal decisions, people that have control over financial decisions.
And are there any exceptions to the beneficial owner requirement? Or
Children?
Children, okay. So many children-owned companies?
Well, you know, it happens, and I think it provided for if somebody who's under 18 inherits something from a tragic accident involving a parent that was a business owner. Typically, those kind of things go into a trust, and that child would be considered, but for the fact that they're a minor, a beneficial owner.
Okay, well, thank you. Now, is there a difference in reporting requirements and timelines between companies that were formed before 24, during 2024, and then after 2024?
Yes, absolutely. Good question. Any company or enterprise, I call it, because remember, it applies to corporations, LLCs, limited partnerships. Anyone that was formed prior to January 1 of 2024 has all year, all of 2024 to comply.
So December 31st?
Correct.
Okay.
Any company that's formed during calendar year 2024 has 90 days to comply.
Okay.
And any company that's formed on January 1 of 2025 or after, so next year, only has 30 days to comply.
Oh, okay. Very short time frame. And is there different information they need to give if they're formed after 2024?
No, everybody has to provide the same information, and information that's required to be provided is name, address, birth date, and some identifying number, say from a driver's license or a passport.
Now, I believe sometimes there's a company applicant that is required to be reported?
Yes, that's true. And so a company applicant is defined as the person who actually forms the company or the person who files the documentation with the Secretary of State's office to form the enterprise. So typically that's us, right? The lawyer is required to submit their own information. And the other the definition also includes the person from the enterprise who instructs the lawyer to form the company. So even though that person might not have substantial control over the enterprise, if they're the one that asks the lawyer to form the enterprise, their name, address, birth date, and identification number gets submitted.
All right. And what could potentially happen if a business fails to fulfill this requirement?
Yeah, there are severe penalties. For every day that an enterprise is late in submitting their beneficial owner information, it's $500, up to a maximum of $10,000, and could include 2 years in prison.
Oh, that's pretty substantial.
It's very substantial.
Now, is this something business owners should they be concerned about, like this other government requirement, and do you believe it's constitutional?
Good question. It's definitely something that our business owners need to be concerned about, because it's going to be enforced, and at least for now, and failure to comply could expose you to the penalties that we discussed, and so it's really not worth the risk. We haven't seen any prosecutions yet because the timelines aren't yet up, but we'll see. The problem that I see is it being enforced by different jurisdictions in different ways. It's not going to be universal all across the country. It's going to depend on various federal law enforcement agencies of the particular districts that people live in. You asked whether I think it's constitutional or not. When I first read this, read the act or heard about the act, I thought, wow, that is overreaching. And I immediately thought of Big Brother. Right? It's Big Brother getting into the affairs of our small businesses. And just recently, in fact, on March 1st of last week, a federal district court in Alabama ruled that the act is unconstitutional. Now, what's interesting about that is Alabama's in the 11th Circuit. Here in southwestern Pennsylvania, we're in the 3rd Circuit. So what's going to happen is it's going to there will be further constitutional challenges on this act in different district courts, in different circuits all around the country. And it's going to take time for those cases to sort of bubble up and reach the circuit level. And the circuit court opinion in the circuit where your state is located is what's going to control. And only if we get a disagreement between circuits, right? Some circuits might say it's constitutional and others might say it's unconstitutional, then perhaps the United States Supreme Court will take it up and decide. But for now, it's still constitutional in Pennsylvania, which is in the Western District of the 3rd Circuit. So if you ask me, do we need to comply? Because of the Alabama Federal District Court's opinion, yes, we still need to comply.
All right, so our chamber members still should be mindful about complying with this law.
Absolutely.
And how can the Lynch Law Group help chamber members and other organizations comply with this law?
Yeah, well, filing the information can be complicated. Knowing who to include can be complicated. So I think that companies or enterprises will need to get some advice. Failing to provide the accurate information needs to be corrected, and if it's not corrected, there are penalties that are associated with that. So it's really not worth the risk to try to go it alone. I tell clients when it comes to these kind of things, I don't work on my own teeth and I don't change the brakes on my car, because there are people that have been properly trained to do those kind of things far better than I can do them.
All right, and how can our chamber members reach the Lynch Law Group?
Well, you can reach us at our telephone number, which is 724-776-8000, or our website, which is the Lynch Law Group, www.lynchlaw-group.com.
Well, thank you, Dan. Thank you for doing this, and thank you for educating our members. And I also like to thank the Pittsburgh North Regional Chamber for giving us this opportunity to educate our membership. Goodbye.